If you're a trustee and a beneficiary is accusing you of wrongdoing, or you've just been served with court papers, I'm sure you're feeling overwhelmed. You agreed to serve as trustee because someone trusted you. Now you're facing criticism, conflict, and possibly litigation. I'm Ben Fox, a California trust litigator, and in this video, I'm going to walk you through what these claims usually look like, what your legal obligations are, what your risks may be, and how to protect yourself strategically. Let's start with asking why trustees get sued. Here's something important to keep in mind. Being accused is not the same as being at fault. Trust disputes are actually somewhat common. Beneficiaries may bring claims because they're frustrated about the timing of distributions. They believe another beneficiary is being favored. They don't think they've received enough information. Or emotions tied to grief are driving decisions. In many cases, trustees are sued not because they were dishonest, but because someone is upset. That distinction matters. Most lawsuits against trustees fall into a few predictable categories: alleged breach of fiduciary duty, failure to provide an accounting, claims of self-dealing, improper or unequal distributions, or petitions to remove the trustee. Some claims have merit, some are misunderstandings, and some are strategic pressure tactics. The legal question isn't whether a beneficiary is upset. The question is whether you have acted reasonably, in good faith, and according to the terms of the trust. The law does not require perfection. It requires reasonableness, loyalty to the beneficiaries, and adherence to California law and the terms of the trust. If you suspect litigation is coming or a lawsuit has already been filed, here are your immediate priorities. Number 1, do not respond emotionally. No angry emails, no defensive explanations in writing. Anything you send can become evidence. Number 2, preserve all documentation, emails, texts, bank statements, accountings, notes, everything. Number 3, do not make additional distributions without legal advice. Trying to fix the situation financially can increase your exposure. Number 4, speak with a trust litigation attorney early. The strategy you choose at the beginning often determines how the case unfolds. In many situations, trustees who are acting in good faith are entitled to use the trust assets to pay for their legal defense. However, if a court later finds that you breached your fiduciary duties in bad faith, you could be ordered to reimburse the trust. This is why early case evaluation is critical. You need to understand your exposure before making strategic decisions about fees and defense. Trust litigation usually involves a petition filed in probate court, written responses, exchange of financial documents, depositions, mediation, or possibly trial. Most cases resolve before trial, but favorable resolution comes from preparation, not reaction. When it comes to your personal risk level, trustees often worry about personal liability, being removed, paying damages, or paying attorney's fees. Your actual risk depends on the strength of the legal claims, the quality of your documentation, whether you follow the terms of the trust, or whether the trust has language that protects you as a trustee. If you acted in good faith and kept records, you may be in a much stronger position than you think. A strong defense may include demonstrating compliance with fiduciary duties, showing beneficiary consent or waiver, proving reliance on accountants or financial advisors, challenging weak or insufficient claims, seeking court instructions to protect yourself, or negotiating settlement through mediation. Every case requires a tailored strategy. Sometimes transparency resolves the issue before full-blown litigation, and in other situations, litigation is required for resolution. If you are a trustee under fire, timing matters. Early legal guidance can limit personal exposure and preserve trust assets, prevent escalation, and protect your role and reputation. At Fox Law, trust litigation is our sole focus. We help trustees assess risk, build defense strategy, and move forward with clarity. If you perceive a threat, a demand letter, or court papers, we invite you to visit foxtrustlaw.com to schedule a no-cost initial consultation with our experienced trust litigation attorneys. The earlier you act, the more control you keep.